All right.
Hi, Your Honor, Judge.
Southwest.
She was found just supposed to go to Burnings.
All right. So, once you've been found incompetent, there's nothing that the court can do until they determine that you regain competency.
Yes, because I did mail in a motion recently to fire my lawyer and to
Okay.
replace my court-appointed lawyer. He has not communicated with me at all, and this
Okay, let me-
incompetence issue has thrown me for a loop, and it's
Mhm.
really freaking me out, and it's just not true.
Okay, so this is what we're gonna do. We're gonna call you back for another date. All right, and so I'm gonna talk with the magistrate's court and see what's the best date to bring you back, all right? So the deputy is gonna take you back now, and at the next setting, we'll make sure your attorney's here, okay?
Okay, and I can't do anything about this because he's never communicated with me at all.
I'm gonna make sure that
sent him
happens, okay?
Letters, and I know I'm not incompetent, and this is very frightening, and I don't know the repercussions of
Okay,
it.
so I'm gonna make sure that that's taken care of. We're gonna bring you back, okay? All right, have a good day.
Thank you.
You're welcome. Good morning. Thank you for dressing appropriately for court. All right, on this case, today is your plea deadline date. So have you all reached an agreement or do you want a jury trial?
We have not reached an agreement. We need a jury trial.
All right, and I'll need to make sure that you all have your acknowledgement of discovery. All right, so your plea deadline date has expired. The court will not accept any plea bargain agreements in this case without good cause. Otherwise, you have to plead open to the court. Do you understand?
Yes, ma'am.
All right. How long do y'all expect this case to last?
Say 3 days. Tops.
All right, Ms. Ferguson, I need a jury trial date, 3 days.
Yeah, give me just a second, Judge, I want to make sure it's not all done. Okay, February 10th.
All right, that will be your jury trial date. Counsel, is there any motions that need to be heard?
Not today, though.
All right, just have a seat. Once you sign the reset form, you'll be excused.
Thank you, Judge.
You're welcome. And counsel, if you'll make sure you sign the acknowledgement of discovery before you leave.
Sorry, I'm sorry.
Some. All right, if everyone can please whisper. Court is calling 2025 CR 010818. State versus Julian James Montes Jr. Can I have parties announced?
Bob Braubach for Montes.
And are you Mr. Montes? Counsel, have you received all discovery? Did you review it with your client?
Yes, ma'am, I did.
Court will find that the state is in compliance with discovery. Mr. Montes, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, ma'am, we do.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Montes, did you review court's admonishments with your attorney?
Yes, ma'am.
Did you understand it and sign it in all the appropriate places? You're charged by indictment with possession of a controlled substance, penalty group 1 gram to 4 grams. That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to present you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, he's mentally competent.
I'm sorry, if I could have that trial court certification back. Thank you. Mr. Montes, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
Oh, Your Honor.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, sir.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry into the country. Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, sir.
According to the plea, punishment is to be assessed at a cap of 6 years in the prison. There's $1,000 fine, and the state is silent on your application. Did you understand that to be the plea?
Yes, sir.
Defense?
Yes, ma'am.
State? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, sir.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there been any such motions?
No, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor, seat offer seats, exhibit 1 and all.
No, no objection, Your Honor.
Did you review the waiver and stipulations with your attorney? State you may be excused. Did you understand it and sign it in all the appropriate places?
Yes, sir.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Counsel, if you want to request a PSI and TAP evaluation, it will take approximately 8 to 12 weeks because there's a backlog.
Yes.
And, or if you want, he can be brought back sooner, probably in about 2 weeks, and you can bring whatever evidence you want the court to consider.
We can come back in 2 weeks.
All right, and you're waiving PSI?
No, I think we want a PSI. I think
All right, so then that's 8 to 12 weeks.
we'll do the PSI.
All right, I need a date for PSI and TAP.
January 8th.
All right, we'll see you back on January 8th. At that time, I'll make a decision on your application based upon whatever evidence is presented to the court. All right, thank you.
Judge.
Have a seat, sir.
All right, and Rick, are you all handling both cases?
And Hunter Morris is here on the other one.
All right.
Oh, I'm sorry.
Hunter?
No, I'm sorry. No, I'm sorry. Wrong.
Oh, wrong-
That's
wrong
my other-
person.
Never mind, Hunter.
All
CTD is handling the felon possession.
right, but Hunter, we still appreciate you. All right, so today is a plea deadline date.
And we're gonna reject that. We'd like a trial setting.
All right. So how long do y'all expect this trial to last?
I'd say so.
I'm sorry,
3 days.
3 days. I need a jury trial date, 3 days, and counsel, if you'll make sure you do an acknowledgement of discovery,
Yes, ma'am. I'll work on that.
February 10th.
February 10th.
No, I'm putting this down. I'll get you out of here in a second. I'll meet you then. Oh, okay. It's the next one.
All right, thank you for dressing appropriately for court. Once you sign the reset form, you'll be excused.
Thank you.
Oh, I was just hanging to see when Mr. Draper. gets
Yeah,
reset.
I'm gonna put that on the,
All right. So on this case, do you have all the discovery?
No, Your Honor, and we've made an appointment for 1:30 on Monday to review a video that the nature of the video is such that we can only view it in the DA's office.
And that's the only discovery?
I believe so, Your Honor. What I want the court to understand is it could be dispositive on the video if, when we view it. I don't want to say too much,
Mhm.
but I think you understand what we're talking about. And if we need to try the case, we're probably going to request some CPS records.
No, the CPS record should have already been turned over
Okay,
because that was, you also, or either the court mentioned CPS records in September. So you should already have CPS records.
okay. I'll check with Mario, my co-counsel on that, Your Honor. You could be correct.
Hmm.
So, but we're gonna, on Monday at 1:30, we're gonna view the video.
All right, Ms. Ferguson,
Yes, ma'am.
set this for the second week. Y'all will need to confer off docket. Set this for a second week in December for a plea deadline date.
December 11th.
All right.
And we will get an email on that, Your Honor.
Oh, however, he's gonna have to sign a reset form.
Okay, thank you.
All right, thank you.
Sure, you can wait in the gallery. Thank you. And have your client sign it and bring it back to me and I'll give him copies.
Good morning. All right. So how are you doing today?
They're not fun.
Okay. All right. So on this case, where are we on discovery?
Your Honor, this time it looks like we are missing quite a bit. I'm not sure that I need to get it complete. I think we have it. I just need to get it. But it is a surveillance video and it is phone extraction and multiple computer extractions.
All right. And then is there any CPS records?
Yes, Your Honor.
Any school records?
Your Honor, in this case, there are 6 different victims. So I don't have any school records at the moment. Defense is not requested.
Are you going to be requesting school records?
Your Honor, I don't know because I haven't gotten the discovery to start off with.
School
got-
records?
Mhm.
So if there's school records, is there any type of therapy records? Just make sure they're available.
Your Honor, one other thing
Mhm.
is in any type of sensitive case like this, I always have my client watch the forensic interview with me.
Mhm.
And we want to arrange a time and maybe during the holidays, it may be a good with that, when you don't have a jury, that Mr. Casares can be brought over, but in the jury room to allow us to watch it or
Yep.
stay in the courtroom if the courtroom is clear.
You'd have to make an arrangement with the deputy, so speak to them about the scheduling issues, because they will be in charge of security. And if
Mhm.
you all will both get a date from them.
Your Honor, one thing that came up is the state wants to be present during the time that my client and I watched the video.
Why?
I've never had anybody, the state present. I've had the deputy present. Oh, no, it's okay.
We never discussed this yesterday with a different case, and that was a solution that came up. So, like I told the defense counsel, I don't mind asking it whatever way. I'm totally fine with that.
Okay, great.
Mhm.
Yeah, and if we can do it, yeah, but yeah, the holiday may be a good time because it's a little without a jury,
Okay.
so we can get that
All
scheduled,
right.
Your
But
Honor.
what I can tell everybody is if there is an issue with her and her client being allowed to view it alone, and when I say view alone, the deputies will have to be here because he's in custody. But if there's another issue, we can have a hearing on it. And what I can tell everybody, I don't think that it is appropriate for the prosecution to be present when a defense attorney is reviewing evidence with their client unless the defense attorney has no objections to it, because maybe they want to discuss issues. Now, because your client is in custody, the deputies will be present because they're in charge of security.
And yes, Your Honor, and I
Yes.
think that was more to, if we couldn't get a jury room and we had to do it upstairs in our conference room, So we just need to work out logistics.
Mhm.
All right, thank you. Ms. Ferguson, I need a reset for discovery. If you can set this in late January.
Yes, ma'am.
All
Like a good day.
All right, thank you. And then if you'll discuss with the deputies a date to have him brought over to view videos.
Thank you, Your Honor.
You're welcome.
Thank you.
You're welcome. Good morning.
This is the individual who's in federal custody.
All right, so what are the federal dates?
He's already been sentenced. He's in federal prison. His
Okay.
mother's here. She informed me that she thinks he's gonna land in Fort Worth. I told the prosecutors that. They've, I guess, been working on trying to get him.
All right, so is this going to be a jury trial? Okay,
I couldn't tell you. I
how
don't,
long do y'all expect the trial to last?
just simple, 3 days.
All right,
Yeah.
Ms. Ferguson,
Yes.
and if I could see the state on carry on. All right, Norma, on this case, if you can set it for a jury trial date and a plea deadline date, December.
We did try to get him here from the Fed, and they told us that it's gonna be another 6 to 8 weeks until they can release him.
Hasn't he already been sentenced?
He's in transit from whatever holding facility he was at to his like final resting place for prison, like the facility he's going to be housed at, and they said that they can't release him to us until he gets there. So we were told it's gonna be another 6 to 8 weeks. until we have-
We'll see. All right, Ms. Ferguson, set it for December.
Number 9.
All right, counsel,
Sure,
December 9th.
thank you. Judge, I
Thank
have
you.
another individual who is on bond.
Just 1 second. I have to put this in the system.
Judge, the state has made us an offer and we're not declining it. My client has a job in which he's working 6 and 7 days a week. We're sort of contemplating things. I also open up their file today.
Okay, I'm sorry, I cannot hear.
Oh, I'm sorry. And then I also opened up the state's file today and there's several disclosures about officers being under investigation. So I need to look into those sorts of things too.
All right, state. Disclosures concerning officers.
I'm sorry, on Joseph Rodriguez, there are a number of disclosures in there. I was on the dead, I want to look into what this one.
Okay.
So make sure they're available for him.
The disclosures are in the file. If you think you need something more than what's in there, then he'll just let us know. We'll work on it.
All right, Norma, set this for a plea deadline date in December. This will be your final plea deadline date. The court will not extend plea deadline date further. Norma, if you'll just put it on December 9th as well.
Okay.
All right, is there anything else? Do you have any questions?
No, ma'am.
All right, thank you. Just have a seat. Once you sign the reset form, you're excused.
Thank you.
You're welcome. All right, and this appears to be criminal trial division and also family violence. There's a new case.
Pick.
Oh, it's Pick. Hi.
So Judge, just the backstory. So I've been coming to court repeatedly on the family violence case. There's been a case with Pick, or a couple cases with Pick that have been kind of percolating. And then he was indicted, I guess, on how many counts?
I'm gonna get out my
Okay.
multiple, yes. 8 counts, Judge.
All right, and is that on the kidnapping?
Yes.
Okay.
So I've been appointed to those cases now. I don't have any discovery on them. So obviously, I think the discussion all along was those are going to be the cases we were going to try. I'm a bit taken aback by the 8 different counts, a little, I think, overreached by the previous prosecutor. But nevertheless, I'd ask for a discovery deadline so I can try to get the discovery on those new cases and figure out what I'm doing with them. And then on a side note, he tells me when he was magistrated on the new cases, no bonds were set.
Mhm.
So, which I found kind of unusual, but I don't know who did the magistration, but I'd ask the court to set bonds on those cases. I don't see why he wasn't given a bond when he was magistrated.
All right, and this is on the newly indicted case?
Yes.
Yes, Judge, if the sport says. You have to report.
All right, do y'all want to proceed with an oral motion to set
I
bond?
would, Judge.
And state, are you prepared to proceed?
Make sure I have everything. This would be enough, Judge.
All right, thank you.
Yes,
And what I can tell you is on the 2024 CR 0924 case, which is the assault family household. Let me see. Okay, he has a bond on that one.
He was out on bond when all with these new cases finally got indicted.
Okay. All right, the court is calling 2025 CR 013272, State versus Jonathan Dreamer. Can I have parties announced for the record for the state, for the defense?
Robert Mauer.
And are you Mr. Dreamer? All right, defense, are you requesting a bond?
I am, Judge. I'm requesting the court set bonds on the cases that he was magistrated on, but no bonds were set.
All right. Any objection to the defense having an oral motion to set bond?
None, Judge, but the state would like to proffer a report from this court's review.
All right, just one moment. Any witnesses?
No, Judge. I mean, I can tell you, look,
I'll
for
need,
purposes of the bond hearing, I guess I can call Jonathan Dreamer.
all right, could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
They need to speak louder.
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Jonathan Dreamer.
All right, defense, you may proceed.
Jonathan, I know you've been incarcerated
Just one
since,
second, I'm sorry. Everyone, please whisper, we're on the record. You may proceed.
you've been in custody since you were picked up on these new charges, correct?
Yes, sir.
Do you, I guess, once you were arrested, you lost your job, is that correct?
Yes, sir.
Do you have any family who can help you make bond if you're given one by the judge?
Yes, my my niece and my sister.
Okay, and do you know how much money they have set aside or can get for bonds?
They don't make much, but I know they could at least get like 1,000.
Okay, and do you have bail bondsmen you can work with that you might be able to work payment plans with?
Cowboy bill.
Okay, all right, I have nothing further to.
All right, state, any questions?
Mr. Dreamer, were you on bond in the family case when you picked up these cases? Or did these have the prior family case?
Judge, I'm gonna object to any. I mean, if the court wants to review the records, I don't want my client talking about dates, but I think, well, the court's aware and there's judicial record that my client was out on bond. These cases were filed at large when we were coming to court, and then he got picked up once they got indicted.
All right, so here's the court's question.
Yes.
The case that he is indicted on that he doesn't have a bond for,
Yes, Judge.
what is the alleged offense date?
November 8th. That might be a stenographic. error.
Yeah, that's an error.
So November 8th of 2023.
All right, and then the case that he previously had bond for, you're saying the assault family violence case, what's the alleged offense date on that case? State, you may proceed.
No additional questions.
All right, I have a few questions, and it's questions that are related to bond. First, in defense, if you know the answer to this, you can answer it, or your client can answer it. Has there been any type of mental health diagnosis in the past, or any type of mental health medication that has been previously prescribed to your client?
There's nothing that I'm aware of. Did you have any sort of previous psychiatric?
No.
And there was, I know they do mental health evaluations at the jail, but I didn't receive any red flags
Okay,
on that at all.
and then my other question, in the past, has there been any type of drug use?
Not that I'm aware of.
No.
All right, any other questions?
None from the stage.
All right, any other witnesses?
No, Judge.
State, any witnesses or evidence for the court to review?
Yes, Judge.
All right, the court has reviewed state's exhibits 1 and attachments. Any other evidence?
No other evidence.
All right. Defense, what amount? I'll just figure out what amount you're asking for and then I'll hear argument.
Well, Judge, I can tell you, I was a bit taken aback by the sheer amount of charges that were filed because I think the previous discussions didn't quite encompass all of those. I mean, obviously there's a bond schedule in place, but I'd ask the court to look to the low end just based upon the sheer number of counts that were filed. I think a lot of those are probably going to go away. I'd ask the court to set bonds on each charge at 25,000. I think it'll be hard for them to make it, but it still gives them an opportunity. I don't think there was GPS in place before, but that might be appropriate in this circumstance if the court is concerned about safety to the community.
State,
Judge, is this court setting bond by case number or by count?
case number.
Case number?
Yes.
Yes, the cumulative bond on the case be 150, the full GPS if released.
Well, if it's all in one case, then I'd ask the bond be set at 100.
All right. And I'm saying all in one case because it makes it easier for the clerks.
Sure.
And so this is under cause number 2025 CR 01327. And what I can tell you, Mr. Dreamer, according to new case law, you're not entitled to bond, but I haven't received the evidence on the previous allegation of the assault family violence to make a decision to deny you bond. But this is what the court will do. There's to be no contact with the complainant. There's to be full GPS, waive fees, and the court will set your bond at $200,000. And I need a date for discovery on this case, please. And counsel, I know the previous discovery date on this case was today, but you've been in jury trial.
Yes, ma'am.
All right, so if we could do a discovery date for that last week in December.
I'll be here.
All right, so your discovery is going to be December 18th. And if someone, I'm going to give you all a blank form. If on the blank form, if you could write down the court's ruling with regards to the bond motion so that the clerks may have it.